So I'll be presenting the most awaited piece of legislation we have been struggling with for past 75, 76 years, the Arbitration Act. As we all know, as we speak today, the colonial era legislation, the Arbitration Act of 1940, is the main law governing arbitration agreements, procedures, and domestic arbitral awards. The Arbitration Act was recently revisited to produce the Arbitration Act 2024 as the UNCITRAL trade law compliant edition added predecessor. So just to give you an idea, model law is a comprehensive piece of legislation that covers all stages of arbitral process, from the arbitration agreement, the composition of jurisdiction of the arbitral award, and the extent of court intervention through the recognition and enforcement of the arbitral award. In most of the jurisdictions around the world, the one which we call the model law compliant jurisdictions, they have now departed from the court interventionist approach to the court supervisory approach. So that shift we have started to see since the Arbitration Act 1996 in England and Wales was incorporated. We have got more than 46 jurisdictions around the world who have incorporated model law as part of their Arbitration Act in their national jurisdictions. So United Commission, they formulated this UNCITRAL Commission on the Trade Law, who after deliberations over years and years, with more than 45 participants from 45 different countries, they formulated a law which they call the model law. As far as this international arbitration agreement is concerned, internationally, we say we have got 3 pillars of international arbitration. So the whole law comes out from New York Convention, and then we have got UNCITRAL model law, and then we have got UNCITRAL arbitration rules, model arbitration rules. So these 3 pillars, the triangle we call the golden triangle, they gives us the laws, the rules of how to conduct the arbitration process. The main theme and the main idea was to actually have the alternative to court litigation in terms of dispute resolution. And one of the unique features for arbitration, as we all know, is you cannot choose a judge, but you have all the liberty to choose the arbitrator based on their skill set, which is why these skilled arbitrators, they are one of the main features in terms of party autonomy for having the arbitration procedure, especially in contracts like construction, power, energy, where we need people who understand those things. And of course, we need to have, at the end of the day, some court process or some authority on top of them who can overlook and oversee what exactly and how exactly they are doing all that. So I think better late than never. The whole world started to depart since 1996. The India Arbitration Act was also enacted in 96. It was updated in 2015. The third version was in 2021. And now after that amendments from 2021, we can now see the arbitration have started to get popular in the Indian side. Why I'm quoting this? Because the lifestyle of the people, most of the things we can correlate. When we say we are a litigious society, we can now see the alternatives to dispute resolution. They are now being incorporated in this region, the South Asian region as well. So I'm going to give you an overview, just a basic overview without taking much of your time, the distinct and the specific features of the Arbitration Act. So the number 1, district court will be the competent court as compared to the civil court. So the shift from court intervention approach towards a court supervisory role, and then the introduction of cost follows the event, the power that has been given to the arbitrator that they can impose costs, and the direct award enforcement, like evading the procedure for making it the rule of court, and then direct execution of arbitral awards and the potential of appeal. So evolving from domestic arbitration to foreign arbitration, this act also encompasses and involves not just the domestic part, but also the international part of it as well. And then the Constitution, the idea of developing an arbitration council, that is also one of the unique and distinct features that has been added in the Arbitration Act. So the composition, the way it is working is that these district courts, they will be the courts who will be supervising the arbitration process. So anything that goes wrong during the arbitration proceedings, that can be brought before the supervisory courts. Of course, I understand there are very narrow grounds that can be taken up, because the idea is not to intervene during the process, but the supervisory roles allows you on very limited grounds to intervene. Otherwise, they will let the award to be issued, to be rendered, and then the award can then be tested before the same court. So by eliminating the civil court, I think the civil court, which is the court of the first instance, is the one which is the most populated, the one which takes more time, between 8 to 12 years. So if we can eliminate that, and if we are directly in the district court, which means we have already taken up the matter that one of the appeals will also be exhausted. So the only appeal from the district court will be the high court, and then on very limited grounds you can go to the Supreme Court. So how this is going to impact the reduction of case duration in the civil court, enhanced overall dispute resolution efficiency, and streamlined arbitration process. This is what we are looking for. So introduction of cost follows the event. I think if this feature is incorporated in the Pakistani legal system, this can actually change the dynamics of how the litigation takes place. I'm not sure how easy or how difficult this is going to be, but even in domestic arbitration awards, the arbitrators are commonly granting costs to the winning party. So this is one of the distinct features which is made available as per the Model Law Compliant Arbitration Act. Going on to the court interventionist approach from towards a court supervisory role. So intervention at the 1940 Act actually allows the courts to intervene on 4 different stages, and actually we don't have any other option rather than to bypass them from appointment of an arbitrator and for different other applications. The supervisory role means that they will not be intervening in the arbitral process throughout. They will let the arbitration process take its place, take its due course, to the point when the award has been rendered by the arbitrator, which can then be, through an application, be tested before the district court. And the court can then see, on the basis of those 3 limited grounds which are available in the Arbitration Act 1996, we call them section 67, 68, and 69. Those same powers will be available to the district court in terms of testing the award. So direct award enforcement. This is also one of the key features. Once, as per the Arbitration Act 1940, an award has been rendered, we have to take it back to the civil court so that we can make it a rule of court. And it takes another few years to get it, to make it become a rule of court before we go into the execution. But just like in international arbitration awards, when an award comes to our jurisdiction, we are readily available to enforce that award without any such intermediary action to be taken. And the same way, the proposed Arbitration Act 2024, it allows the award to be enforced as it is, as per se, without any formality of making it rule of law before any court. So this is also one of the key features which will reduce the timelines in reaching out to the eventual execution of the award. So the potential for appeal, you can give an application to the district court once the award has been issued, and from that application there is a provision for appeal to the high court, and there will be one judge of the high court who will hear the matter, and once that appeal is exhausted, I think that should most probably end up the litigation. So we'll have two places to go: one, the district court, once the arbitration award has been issued, and then the high court. And probably if this is implemented as it is, it will reduce the entire burden from the process from 10 to 15 years or 12 years to civil court, and then 3 to 4 years in the district court, then going on to the high court, and then going back to the circles. So I believe these two elements of direct enforcement and eliminating the civil court and making the district court, the supervisory court, will play the most important role for these. So the another feature in the Arbitration Act 2024 is it will cater the international arbitration as well, not just the domestic arbitrations. Of course, we need to have one of the parties to be foreign in order to qualify for the international, to make it an international arbitration. And for those the award that will be rendered, that will be treated as an international award, which can then be enforced probably anywhere in the country as an international award. Another unique feature is they have incorporated the IBA guidelines, which usually in international arbitration practice, we as practitioners, it is considered to be a soft law. It is not mandatory to be adopted. They are adopted in case of in case when both the parties are agreed, or in case when parties are unable to decide upon in any of such rules. The arbitrator has got the prerogative to pick upon or choose any of the rules. IBA rules give you the guidelines on a number of things. They have got green, orange, and red traffic signal approach in terms of impartiality, in terms of independence, in terms of whether you can take up the case and whether you should resign, or you should not be taking up. So these are the elements which are already incorporated, which I believe is going to give a fair idea rather than putting the burden on the arbitrator to choose. They will be then bound to go upon exactly on those lines. And then also the Arbitration Council. So in Punjab, there is an arbitration, the ADR Act 2019, which was amended in 2023. The amendment in 2023 actually was made to incorporate an ADR authority. So that similar sort of feature has been incorporated in the Arbitration Act 2024. The main features for the Arbitration Council will be to register and overlook the arbitration process. They will come up with the rules and the qualifications of who can be an arbitrator. The arbitrators will then be regulated by the Arbitration Council. The ADR centers, or the arbitration centers to be specific, they will be regulated by the arbitration councils. So if in any case of matters that needs to be taken up, instead of going to the court, the arbitration council can play its role, which I believe is going to play a vital role in in overseeing the whole. So what the general impact, I think it's not just the court litigation system which is going to become efficient. It's not just that we are going to see that a lot of cases which are being referred to the court just because of the inefficiency of the arbitration procedures itself in Pakistan. They will then be referred back to the arbitration. We can get that confidence, at least from the commercial side, towards the arbitration process. It will also give the confidence to international investors in terms of foreign direct investment, because I think that FDI is directly related to the mechanisms of ADR which are available in any country. So if we have the appropriate ADR methods and if we have a model law compliant act we have as the national jurisdiction, that gives the confidence to the investors that it is a safe place where they are actually complying with the model law, which was actually missing, and it's not just the sovereign guarantees that can bring in the investment. Formation of rules, institutional arbitration, there is a lot to be talked about. I've only had 10 minutes, and I just wanted to give a brief overview that these are the salient features. There are some deeper levels of it, and I hope this Arbitration Act is going to change the entire legal system of Pakistan.